Nicholas Mkoma Mkali, Wisdom Goro na James Mwandondo. Mtawapa nafasi tafadhali This is who? James. Hawajaingia wengine. You'll come back on the 20th of June, 20th of June. Roslyn Wanjiru? Roslyn Wanjiru? Ayo. The warrant shall remain in force. 20th June for mention. Amor Omar Ali Abdulrahman. We'll mention on the 12th of June. Okay.
You?
Eh? No, let him sit. Please sit. Just hold on. I'm waiting for the file. Eh? There is something that has not been done. Let me note the appearances. Mr. Tukor.
Before I give you the forum,
Yeah.
Mr. Mogolo last week was attacking us that we had occupied the front seat.
That you're not?
Today,
That you hadn't done what?
occupied the front seat.
Uh-huh.
Now today is debating and throwing the state back to the bench.
One of you, please give Mr. Kiprop space at the front.
Your Honor, what is not disclosing, later can confirm this.
Yeah.
When I saw he was likely going to miss seat, I confirmed it later. I even requested Linda. They were brought 3 seats, which they did not think were comfortable. They took here. Then those
Because
three seats are
give
now-
him a seat at the front because the state is the state.
Yes, that's when I was pleading with you.
Yeah.
Ask even Mr. Mari, I've been asking Mr. Kito, please sit here, and he has refused.
Mr. Magolo, eh?
Yes.
Do not offer Mr. Kiprop a seat that doesn't look very comfortable. Eh?
I didn't realize that. I just saw 6 or 6. But particularly what it is an occupied by Mr. Umbrella because it swings.
We have been having a debate.
Yeah.
Is it them who are senior or is it the attorney general? It's a serious issue. But that is off the cuff. We can have a seat.
Mr. Kiprop?
Thank you. Yeah.
We are here because
Oh, you wanted to be under the fire, no? Yes.
Yes, Your Honor, I appear on behalf of the state,
Yes.
together with Mr. Susioka
Yes.
and Mr. Singh. For the
Mr. Kiprop, Mr. Musioka, Mr. Singh.
Mr. Singh.
and for the defense.
Yes.
We have Mr. Mafolo,
Yeah.
Mr. Meta, Mr. Wamboi Shaka,
Good morning. I am Mr.
Mr. Osoro, I'm President, Mr. Egesa, Mr. Koko, and Mr. Kai, together with Mr. Omari from the defense.
Anyone who has been left out? No, that is what we refer to as a battery of lawyers, eh? or an argument of lawyers. Any other appearance? The LSK? Not here today. Mr. Kiprop.
Your Honor, pursuant to your ruling delivered on 2nd of May 2023, we appear before you for the state to give the status report on the ongoing investigation. Your Honor, this morning we filed a further affidavit.
I haven't seen an affidavit in this file.
Your Honor, the investigations are still ongoing.
Give me a minute.
Sorry?
Your Honor. In fact, I wanted you not to even read it.
It's part of the record, Mr. Ondeta. Is the affidavit served upon the respondents?
Yes, Your Honor, we have served the affidavit.
Are you standing on the preliminary point?
Yes, yes, yes.
Yes. Yes.
Your Honor, this is a matter that you had already made a decision on the last time we were in court. I believe that if the state wants to reopen up this matter, and they are coming by way of an affidavit, they should seek leave of this court, first of all, to file in a further affidavit.
Mr. Ondeta,
Yes.
my view then is that
Yes.
you respond after he has made his submissions.
Yes.
Then you can state all that you're stating. Yeah.
Your Honor, what Mr. Cliff is trying to say
Yes.
that if they are allowed to argue the application, there's no application before. The question we are raising is just like appeal. Is there anything before you? So that once the court pronounces itself that there is a document before you competent to be submittable, then they can submit.
But that can very well be part of the response. And the court will make a decision.
We are avoiding the question of content being submittable. Then we respond. We are simply seeking a procedural question. Once that procedural question is dealt with, then
Okay.
substance can be.
All right. Then raise your point, Mr. Ondeta.
Yeah, but please, then join.
You know, we were saying that a further affidavit in a matter that has already been determined by the court cannot be extended by a further affidavit. It does not have a life of its own. So the first thing they needed to do was to seek leave of this court, which they have not done. So from the word go, you need to stop them at this particular moment. Your Honor, the application that the affidavit that is in court right now seeks to asked that the respondent here be held for a further 30 days.
And that is the problem.
Yes.
You want me to disregard that affidavit,
Yes.
yet you are referring to it. How do I do that without going into it?
Well, let us start by the issue that they do not have audience before you without seeking leave to file that.
You are to address our submission.
Yes, Mr. Omari?
You are not to address that position of my learned senior Mr. Cliff
Mr. Ombeta.
or Mr. Obed. Courts will only issue orders specifically prayed for the law of such orders is not in affidavit. An affidavit is evidence. A notice of motion needs to be placed supported with the grounds under supporting affidavit. The law on miscellaneous applications is anchored on the civil procedures. It's nowhere in the criminal procedure code. Therefore, this document is incompetent. For this purpose as a document to be presented before the court for the purpose of seeking orders. Now, secondly, the matter before you E075 is already determined. It can only be appealed against it cannot be made a subject of review now. When the timeline set by this court has elapsed. One will review sentence.
In 1 more minute, Mr. Omari, 1 more minute. Yes. 1 more minute.
Minute.
Yes.
Your Honor, One will only be allowed to review a sentence when it is running on, not when it is complete. The respondent was sentenced, if that is the right term, for 2 days. For 7 days, he has served. If they wanted to review that decision, it could be before the expiry of that time. Lastly, Your Honor, is that we completely object to such tactics. By the state completely object to these tactics. I wouldn't want to talk about the content of it, but we vehemently object. Let the respondent go home, or a charge sheet will be produced before you. Mr. Soro has only one word.
Your name, if I may.
Hold on. Yes.
Yes, the state has run out of ideas on how to punish the respondent. We came here.
Your Honor, we will object to that kind of language.
I am
I'm not letting that go. Your Honor. The state,
We can fight about this for hours.
we will fight.
And let me finish.
Your Honor, don't allow that kind of language to be used in our courts.
Mr. Osoro,
Let us be polite to one another.
it is okay. That is noted, Mr. Osoro. Proceed.
Maybe Your Honor, then maybe let me paraphrase. The state has something to shifting goalposts. Your Honor, the ruling that was read by the court on the 2nd of May, specifically order number 2, that this matter shall be mentioned on the 4th of May 2023 at 09:00 hours for the state to appraise the court on the status of the investigations and for further orders. The court never asked for further affidavits. The status report on the investigations. You expected to come with the charge sheet or tell us that this is what we've done, or give us some evidence. It will even support their malicious application to keep holding on the respondent. Such kind of documents are what the Supreme Court called hot air. It's full of sound and fury signifying nothing. And this court has the powers to arrest such an injustice being perpetrated by the state. You want to understand?
Can I say just
Hold on, please. Mr. Magoni.
Yes, General, you have heard the objections, and in my view, they all have merit. General, considering the time and the schedules and the need to move, I wanted to say, to request and suggest, Your Honor, that you give us direction so that we proceed, so that Mr. Kiprop, though he really has nothing to say, but can say all of it, so that we don't make application, ask you to make a ruling, we come back again, because our interest now is that Ezekiel should not be in custody any longer. The more we take you around, we may end up keeping it long. I suggest that you direct in a manner that we proceed and finish up, and whatever, and you can even order the strike note of the affidavit, and Mr. Kipto to say what you want to say, we reply, and we finish it.
Your Honor, with all due respect, we appreciate what and we hear their various activities. You have been invited to look at your ruling, which was delivered on 2nd of May, 2023. And particularly, you have been referred to the last paragraph of your ruling, which says that this matter shall be mentioned on 4th of May 2023 at 0900 hours for the state to appraise the court on the status of the investigations and further orders. Your Honor, it is upon this subsection B of your ruling that we are before this court to appraise the court on the status of this investigation, and if there are any further orders that the court will grant, then we will make that application. I'm afraid that is what the learned senior Mr. Kipro had started with. That is the first thing that in his submission he stated, that the court had directed that we appraise it of the status of the investigations. That is when you invited us, invited the states and asked whether the application had been served.
Okay.
So I would agree that we can take directions based on Mr. Magolo's submissions. However, before the court does that, I will invite the court to consider two issues. Mr. Omari raised the question on the matters of civil procedure. This court is guided by the Criminal Procedure Code. And in any event, if the Criminal Procedure Code has not given express provisions on how this court is to be moved, which we are going to rely on C, where we were, one of the orders was we be at liberty to apply for any appropriate orders, which we are currently doing. Then the court is also invited to look at the Constitution, where the Criminal Procedure Code is silent on the way we are to move court. Under Article 159, Your Honor, if I may read Article 159, which I'm sure the defense counsels are well aware of.
Sub-article?
159, sub-article 2D. That judicial authority is derived from the people and vests in the people by the courts and tribunals established under this Constitution. In exercising this authority, the courts and the tribunals shall be guided by the following principles. Now that moves me to sub-article D, that justice shall be administered without undue regard to procedural technicalities. Now, if the Criminal Procedure Code, which is the basis upon which we come to this court, and has the procedures by which we are supposed to move this court, is silent on how we are to move this court, then I invite the court to refer to Article 159, which is the supreme law of the land. And basic law tells us that any other law which is inconsistent with it is repugnant to that extent of inconsistency. So, even as I rest,
1 more minute.
even as I sit down, Your Honor, I invite the court to look at that provision in light of the submissions by the defense counsel.
The ruling on that. The final orders in the ruling that I rendered on the 2nd of May were clear that the purpose of today's mention was for the state to appraise on the status of the investigations and for parties to apply for any other further relevant, desired or appropriate orders. An objection has now been raised targeted at the further affidavit filed today, and the respondents' counsel seek that the same be expunged from the record. By practice, applications made to a court handling criminal cases are either orally preferred or by way of notice of motion. This is a practice that has been adopted in our jurisdiction over a substantive period of time. And that being so, and following the orders on the 2nd of May this year, giving leeway to the parties to apply, it is within the rights of the state to prefer the application orally and base the same on affidavit evidence. There are hordes of decisions from superior courts. I have one in mind, Kisia Investments. I don't remember the other parties. There are hordes of decisions from superior courts that the title of an affidavit, in this case, further affidavit, is a matter of form and not substance. The substance is to be found in the depositions made in the paragraphs where the deponent states is material on oath. It is therefore my persuasion that although the affidavit is titled as a further affidavit, the state can still rely on it to support an oral application. I, however, need to be clear that a decision on the application dated 28th of April 2023 was rendered on the 2nd of May, and I trust that parties will not revisit issues already determined therein, which would otherwise be rendered res judicata. The upshot then is that the objection by the respondent fails. Mr. Yes, Mr. Kiprop, you may proceed.
Thank you. As I was saying, the status reports that we are praising this court about is the new development that the investigators have come across, and I will rely entirely on the government to this affidavit. But, Your Honor, the autopsy reports that have lately come out from that exercise.
I'm sorry?
The autopsy reports
Yes.
that have come out indicate that some deceased persons may have died from strangulation.
Mr. Kiprop, I've read the affidavit.
Yes.
I think you are repeating what's in the affidavit.
Yes, I just want
Unless there is something you really must highlight. I have read the affidavit. Yeah.
the important thing, Your Honor, here is that that information which is in the affidavit was information which was not before this court at the time we argued our application. Your Honor, that information has now altered we have been given by your ruling. I'll ask you today. We are asking for 30 days, Your Honor. Okay.
How long has it been? It's been there for 7 days.
7 days.
So a total of 37 days.
Your Honor, the application, which I heard you say is just judicata, which is something which is sensitive, it's not actually just judicata. It was not under...
Not an application.
Yes.
I said, I did not say the application is for a judicata.
Yes.
I said do not bring up any issues that would otherwise be rendered as judicata. That's what I said.
Now,
yes.
that application, one of the statutes which was premised on that application is Prevention of Terrorism Act.
Yes.
Particularly Section 33. The state can request up to a maximum of 360 days. Your Honor, we are before you and asking for 30 days. I will leave my colleague, Mr. Simbi, to address you on the authorities that we are relying on to buttress our reports and the changed circumstances that is now developing.
Before that, so now it is, you're basically, through what I'm saying here,
Yes.
you're now basically investigating the offense or offenses of murder.
Yes, based on what is coming out.
Yes.
And
But I'm wondering
yes.
whether murder then falls under Porter, although you presented the application under Porter.
Yes, but we are not limited to murder alone.
I'm looking at your affidavit.
Yes.
Because that is the status that I expected.
Yes.
Yes.
And in our application, which you captured in your ruling, we are also investigating other organized crime.
Okay.
Yes.
Mr. Simbi?
Yes, Your Honor. You know what the state is telling the court?
Have you
shared
those authorities?
Yes, I have shared.
With the respondents? Or you're doing it now?
No, I have shared.
This is practice.
And I'm only going to refer to a few lines of those authorities.
It doesn't matter. As a matter of courtesy counsel,
Yes.
hata wewe ukipewa saa hizi, really, it is not fair. Yes. Yes. And even look at the same act you're looking at, Porter.
Yes.
It says, doesn't it say that the application, whatever application, and even whatever you're supporting it with, must be supplied to the other side? Yeah, the same act you're relying upon.
That's right.
Proceed.
Right. So, you know what we are telling the court?
The copies for the court, please. It's just one authority.
There are two authorities.
Let me have all the copies. I also don't want to be ambushed.
But the second authority largely backs up the provisions of the first authority. But basically, Your Honor, what we are asking the court is not something that is new. We are not asking the court to do something that is out of its purview. Your Honor, in miscellaneous criminal application number 162 of 2019, that is the Mukhtar Ibrahim Ali versus the Republic. At page 2 of the authority that I have just submitted, I will invite the court to look at paragraph 12. Line 7, which I will
What page is that?
page 2 of 3 in Mukhtar Ibrahim Ali versus Republic.
Now, you asked me to look at
I invite the
Diana Suleiman, eh?
Sorry?
They cited Diana Suleiman.
Yes.
Okay.
One that cites Republic versus Diana Suleiman side another.
Okay. A paragraph. Paragraph.
From paragraph 10 up there, and I will just quote briefly without going entirely through the entire authority. It says, with respect, I do not agree that the review of bail on the ground of changed circumstances or changes in the circumstances of the case, including circumstances of the accused, witnesses, victims, or the society affected by the alleged crime, is a strange phenomenon. I would say our courts do it every day when they seek to consider renewed applications for bail, such as when volatility on the ground is established to have ceased, or for the cancellation of bail on account of accused refusal to attend court on bail, when surety is withdrawn, or for other reasons. What my learned senior, Mr. Kikok, has submitted, he has invited the court to look at the further affidavit that has been filed, and without going into what is contained in that affidavit, it is the state's position that since the last time we were before you in arguing the previous application, there are circumstances that have changed and that are put in this affidavit, that if the court looks through these circumstances, then it will warrant the court to grant the days that we are seeking to enable the state conclude its investigations. Paragraph 11 of that very authority says the change of circumstances test is one of common sense, that where the circumstances of the case are so altered that compelling reasons are disclosed for refusal of bail or review of terms thereof, the courts as a court of justice must reserve for itself a power to revisit the issue in the interest of justice. And this paragraph, if you read further, and I'm sure your Honor will retreat and read this paragraph, it opens this window to both this state, the prosecution hearing, and the window is also open to the respondent or the suspect. And we are telling the court that from the last time we were before you, there has been a change of circumstance that has occurred substantially that would warrant the court to go through and give a directive or give an order for extension of these custodial orders. So it is open to either side, but it so happens that in this case, it is the state that is moving the court for an extension of this.
The point is all.
Right. Without belaboring the point, as I finish, paragraph 12, Your Honor, on the first 3 lines only, the learned judge says, I find nothing in the provisions of Article 49H of the Constitution or Section 123 of the Criminal Procedure Code to suggest that once the court grants or refuses to grant bail becomes fantastic. It is our submission, Your Honor, that based on the ruling that you delivered the last time we were before you, and in light of the provision of this authority, the court does not become factus official by virtue of the fact that it had pronounced itself to 7 days. This Supreme Court still has the powers, in light of the change of circumstances, to extend or give additional days based on aggravated circumstances or change of circumstances.
Change of circumstances.
Yes.
Can warrant review.
And
that is all.
That is it.
Yes.
So, Your Honor, we are relying on that authority and invite the Honorable Court to grant us the prayers of sort.
Okay.
Basically, Your Honor, without belaboring the point, I believe the other authority also speaks to the same authority. So, without wasting the court's time, I would wish to pray that the state be allowed a further 30 days within which to detain the respondent.
Mr. Magolo.
Your Honor, the application today has reminded me of some things. Your Honor, when I was growing up in primary school and learning the English language, I used to believe that prosecution and persecution meant the same thing. Your Honor, today, in fact, it is confirmed that I was not wrong. Your Honor, we have before you a person who has been in custody for over 7 days. We have before you a person who, when required, over 2 weeks before his arrest, to go to the police station and make a statement, he duly complied. We have before you a person who, after an application had been made, and you looked at all the circumstances, a decision was made that 7 days was sufficient. We were therefore coming before you today to ask that you close this file and discharge Pastor Ezekiel. Your Honor, and it is my submission that despite everything that has been said, that would be the only logical decision you should make. It is now alleged that circumstances have changed. And a struggle has been made, even by way of affidavit and submissions to demonstrate those circumstances. They are not coming out. What has changed? From the application that you dealt with, they suggested that the investigations and the matters which the respondent was suspected of included murder, aiding suicide, abduction, genocide, crimes against humanity, child cruelty, fraud, money laundering. Now, when you look at the affidavit before you today, it seems that the investigations are zeroing on murder. To be subjected to autopsy, such that the result of that autopsy is not something new. It is not something unexpected, and it is not a change. It was clearly a procedure expected. And thus, those results affect Pastor Ezekiel. Your Honor, the affidavit is short, and I submit that the answer is no. We are talking about the deaths which have all along been associated with another pastor called Mackenzie. From some farms which reports say belong to him, by members of a church which was said to be his flock, and Your Honor, now to drag this one here has another name. Its real name is witch hunting. Your Honor, it's my submission, therefore, that...
2 more minutes, Mr. Magolo.
Sir, okay.
2 more minutes.
It's my submission, therefore, Your Honor, that the result of autopsy is not a change. And it's not a change, particularly a change that they say should now amount to a compelling reason. Your Honor, the authorities that have been referred to you are anchored on Diana Salim, which, although properly well quoted and citation given, they opted not to avail. I happen to be conversant with Diana Salim. And Your Honor, the change in Diana Salim, which they are not disclosing to you here, is that Diana Salim had been charged with the offense of murder of one person. Remember the terrorist activities in Lamu. Then investigations revealed the death of other 60 people. Such that the change was from 1 count of murder to 61 counts of murder. That obviously was a change which can be described with its most compelling reasons. The change here is that all other offenses have been abandoned and they are coming to murder, and they now have autopsy results. And I urge that you don't at all give in to that suggestion. So what Your Honor is next? Your Honor, what is expected of you now is to direct that our client be at liberty, because he has not been charged, and there seems to be, other than to persecute him, there seems to be no intention to charge him at all. Secondly, Your Honor, in the event that you feel that you want to give them some more time for whatever reason, though in my view they don't deserve at all, then Your Honor, we urge that you direct that the respondent be admitted to reasonable bail. Your Honor, it's a person you don't even need to ask to deposit cash bail or a surety. He's a non-evangelist. You can only ask him, Pastor Ezekiel, come back here on Monday, and he will come back. He just writes a note as he goes.
So you're talking about a free bond?
Exactly, Your Honor.
Or a personal bond?
You're a personal bond. Even his word without committing it on anywhere, we will still come. That's all.
You know, the affidavit is very, very clear. It needs days for further investigation. 3 things. Post-mortem. He will not be required to be present when post-mortem will be done, so that you detain him, because he will be required.
Postmortems or DNA?
For DNA.
DNA, not autopsy.
His
It says that the autopsies have been done.
Yes. His DNA sampling and analysis will be done in government premises to his exclusion. Number 2, Your Honor, they are saying he is likely to be charged for murder. When they will decide to charge him, he will be available for that charge. He does not need to be in prison or in police custody for him to be charged. You know what? They are saying that he has a lot of influence. Even those who are dead will still have influence. The influence does not wane because he's in prison. It doesn't. He still remains the most prestigious televangelist in this country. So denying him that freedom does not curtail him. Now, let me buttress, so this affidavit does not provide new compelling reasons to keep him. If this affidavit could have said he has contacted so and so and so who are witnesses, denied, that is not true. 2, he has been found escaping out of the country. That is not true. He has made a new passport to run out of this country. That is not true. There is no compelling reason to keep him. And Shadrach will deal with the question of the authority of Oscar Sudi on whether that is the only option to detain.
And I hope you have supplied it on the other side.
No, we have just been given this application now.
Okay.
And they are given the authorities now. Because their trick was, we asked for time to respond so that he continues being there. Now, let me lay the basis for the application for bail. Based on the circumstances that are there. We are urging this court to grant His Excellency Dr. William Ruto were released on board. But their influence, pastor is a shadow, is an entity. They were released and they were doing their matters, and the offense they were likely to be charged is genocide. The offense now has become, I come back to this country. Governors, Obado, the case is there. Governor Governor Waititu, Governor Lenkoro.
I think as you submit,
I'm only giving.
No, as you submit, yeah.
So there is nothing new that has been brought to court today, and this should not take a lot of time for you to make a decision, because it is actually, as my colleague said, hotel.
Thank you, Your Honor. For the record, my name is Shadrach Wamboi. And Your Honor, I begin by associating myself fully with the submissions made by my seniors. And I recognize, Your Honor, coming after my seniors. Ordinarily, I will not have much to say. But with that as it may, Your Honor, allow me to mention that Your Honor, the position that the counsels for the respondent take is that, you know, we do not doubt the immense powers that you have as a court, powers donated to you by law, Your Honor, there has been mentions by my learned colleagues for the prosecution making reference to a particular precedent that has been previously made, over and above the reference to the Constitution. Your Honor, I submit with humility that it is important that when we are making submissions that involve the application of the Constitution, particularly the question whether there is enough ground to continue with the detention of the respondent, it is paramount, Your Honor, that the court also reflects on a book written by Ronald Dworkin taking rights seriously. Your Honor, your ruling of the second day of May 2023 essentially limited the freedom of movement of the respondent. You gave the applicant an opportunity of utilizing the evidence that they had already collected to take any adverse or whatever action that is there against the respondent. Or looked at it differently. You gave them the opportunity of going to look for that adverse information or evidence that they can use, so that today, Your Honor, we can have at least a closure of the file that we have before you and the commencement of what will be criminal proceedings as against you. Your Honor, we are lucky that our client is a revered scholar of the Bible. And there is much that is said about the 10 talents. Your Honor, having granted the respondents 7 days, taking into consideration the affidavit that was sworn by the investigator on the 28th day of April 2023, an affidavit that makes very wild accusations, painting a man of God into those colors. Your Honor, the opportunity that you had given to them has not been fully utilized. And yet, they brazenly approach you, Your Honor, now not asking for 1 or 2 or 3 days, but 30 days, Your Honor. Your Honor, your point of call must be an interrogation of the precedent that was set by Justice Professor Joel Ngugi.
The Sudi case.
Yes, the Oscar Sudi case, Your Honor. And with humility, Your Honor, I will remind the court of the double test that my learned judge then set to be used by all. Your Honor, the first limb of that test, which the court, I am very confident the court has interrogated these issues even before. The question of good faith and exceptional circumstances. Your Honor.
The case of Oscar Sudi,
Yes.
I'm quite familiar with that decision,
Thank you.
so you don't have to go deep into it.
Yes.
Unless there is a particular issue you must highlight.
Yes.
Yes, I well know that decision.
Yes, Your Honor, I make reference to the double test, especially
I
likening it to the facts that
I
we
even have the
faced.
history,
Yes.
including the history.
Yes.
I even know the magistrate that handled it
Yes.
up to the time it ended up before
Yes.
Professor Ngugi.
Indeed, Your Honor. Your Honor, it is important that perhaps even before the court can even consider entertaining the application that is made by counsels for the prosecution, to interrogate the facts my senior, Mr. Magolo, made a very good, at least analogy or submission with regards to circumstances before and now. And what the court might take judicial notice of is that the man who has been likened or associated with the respondent, one Mr. Paul McKenzie, after his arrest, his house was torched. That is an important circumstance that happened post his arrest. The court might want to ask what became of the respondent after his arrest and detention. Your Honor, his followers have been flocking the court compound. The court every morning has been treated to religious songs and dance. Your Honor, that does not speak of circumstances that will warrant the continued detention of the respondent. In any event, Your Honor, I'm not shy to submit that the prevailing circumstances, Your Honor,
I'll give you 2 more minutes.
thank you. The prevailing circumstances, Your Honor, point to a man that is deserving of an order of discharge, or at the very least, release on some reasonable bail or bond terms. Your Honor, in closing, I must mention, Your Honor, we are living in a new constitutional dispensation.
13 years later.
Yes, 13 years later.
Yeah.
And I am sorry and I regret, Your Honor.
And I hope you are not one of those who refers to it as the new constitution. It is
Your Honor,
13 years old.
yes. We have had the misfortune of people living with hangovers of the previous constitutional regime. A regime that did not even entertain the thought of a person accused of murder being released on bail. So that, Your Honor, looking at the current constitutional dispensation, we should not even be astonished or surprised by any arrangements or efforts being made by the state suggesting that they will plan to charge him for murder or for whatever offense that is there under law. Because in the name of the Kenyan Constitution, all persons, regardless of the offense they are charged with, have a constitutional entitlement.
Your time is up. Wind up.
Of bail. And Your Honor, I close by urging the court with humility, Your Honor, consider setting this innocent man free and give them the enough time that they require to complete the investigations. Nothing will change even after the investigations are concluded. Thank you, Your Honor.
Any rejoinder by the state?
Yes,
It's Mr. Musyoka.
yes.
Yes.
Your of interest is the application that was initially brought before you. Just to point out, it was brought under court. In such manner always sought for time. We again come to seek for more time. The court found it fit to grant us time in the first instance on reasons that were well canvassed. Today, we stated clear, indeed, there is change of circumstances, there are new emerging issues, that if time is not allowed to the investigators, we will not achieve justice for the man before you, for the victims. We're not talking of 2 people. We are talking of 100 plus.
Generally, the state is such a process that knows they are only to respond on questions of law. I wouldn't want to teach anybody that. Purely a rejoinder on questions of law.
He has a right to respond to issues of law and any other issues that came up during the response.
Thank you for the question.
Any issues that you brought up during the response, they have a right to respond to them. Any new issue that came up during the responses.
Thank you, Your Honor, that guidance. And that is the reason why, extensively, the defense used certain words, which when I found them very entertaining to the crowd, to say persecution, and again, to say prosecution. There is nothing in law, as we have appeared before, that we can say we are persecuting anyone. It is in the interest of everyone, including the state and the defense, to allow the prosecution, together with the investigators, to come up with any evidence that could be useful to the victims, to the respondent. If there is none, we wouldn't be here. We say so because at great length in paragraph in paragraph 14, we stated that the respondent is a man who has a following. And the following, is not a small following. We are speaking of 45,000 known persons to the respondent, not to the prosecution, not to the investigators. If a man, a single man, has that following, there is nothing more we can speak to explain what influence means. To bring you closer home, the defense was courageous enough to tell us outside here, within your premises, the court premises, people are there.
I wanted to discuss conception, if it's
Just
strange.
here.
I wasn't there, but whatever they told me, honest.
But I haven't given that. Mr. Magolo, Mr. Omari, I've not even heard what you're objecting to.
No, he just started
because I do not know what he's about to say.
What he started to say,
Yes.
the way he said it,
Yes.
that I was told outside here, within the premises of the court, clearly whatever he was told,
Okay.
it does not need to go beyond that.
When I say it was said by the defense,
Yes.
that was said that there are people singing and playing outside.
Okay.
That is my submission. And if that is anything,
Mr. Wamboi actually, was it?
Yes.
Actually saying that.
Yes.
Proceed.
and therefore, that is the same thing, The defense has been saying that prosecution has seen that we are not the winning side. This is not about winning. There is nothing about winning here. It's all about justice. And if one man, can appear before you, followed by a crowd of other people, and it is admitted from the back that they are outside, what else are we asking about if they are not?
The question Mr. Omari was posing,
Yes.
now that he's in custody, how then does that influence when?
I'll come to that.
Yeah.
At least I'm responding to what Dance was saying, that this man cannot even put yes. Secondly, Your Honor,
With some respect, I can call you pastor. With some respect. Kind.
You may refer to him as the respondent.
All the rest of yes. Kind.
I have continuously referred him as the respondent.
Yeah.
And on a light note, Your Honor, the Bible calls everyone man.
Proceed. Proceed, and you have 2 more minutes.
Which Bible?
Your Honor, continuously, the defense, in their wisdom, they chose to invite you to look at Article 3 of the Constitution and disregarded Article 49(1)(g). That is why we are here. Both articles, Your Honor, must be read together for us to be able to interpret the reason why we are here. And the reason why we are here, Your Honor, is simple. To explain to the respondent why we need him in custody and why we intend to have him continuously to remain in custody. That is found in Article 49(1)(g). We have expressed that clearly. If you look at Article 33(1), 1B of order.
Section.
Yes, sorry, section 33, 1B. It speaks of the manner in which we can approach the court. You know, we've chosen the known and laid out procedures. That is where the procedure is.
The section talks about an application served upon the respondent.
Yes.
This was an oral one.
And
The one today is an oral
Yes.
one. Yes.
And the court in the previous ruling today stated that the prosecution may move orally.
Yes, yes. You do not expect that I knew
Yes.
your application before you made it.
Very well.
Yes.
And therefore, Your Honor, we are well guided by that particular section to state that indeed, as we appear before you, we have complied with all known provisions of the law.
Yes.
And therefore, Your Honor, it is only in the, if any, because, Your Honor, there are emerging issues which have been laid out in the affidavit, and those issues are speaking of post-mortem. The defense stated that, Your Honor, there is nothing new about post-mortem results.
Your time is up, wind up.
Your Honor, post-mortem results are very crucial. They are linking us to the cause of death. We intend to have a DNA carried out. That is DNA exercise carried out as soon as possible. It is only fair that this respondent, or the respondent, who is a peace-loving Kenyan as the state and a man of God at the state, which we respect, that he doesn't influence the rest, the family members who are relatives, since it is clear that the victims are also followers in his church.
Where do you get that? That the victims of Shakahola are also followers of his church?
I did not say Shakahola.
Which victims are you talking about?
It is only fair that I respond.
Listen,
No, why?
please take your seat. Court decorum, I'm addressing counsel, the learned Mr. Musioka. I'm wondering which victims are you talking about? Be clear about that.
Yes, we are speaking of victims of the deceased persons. That is the relatives of the deceased persons. And for that exercise, which is a DNA exercise to be carried out, we must have family relatives. That to be carried out, they must avail themselves, and that is our solution. I end it at that, Your Honor.
Yes, Your Honor. Just very few minutes to sum up what Mr. Musula said. You know, one thing that a lot of people do not understand is that prosecutors, by their very job, are ministers of justice. So the issue of persecution, as alleged by counsel, should not arise. Even as prosecutors, from where we seek to establish the truth. But that is what
I do not think anyone has talked about these prosecutors before the court persecuting the respondents. Rather, I think what they were alluding to is the state persecuting, that is the word, the respondents, not your office.
Yes. Thank you for that clarification, Your Honor.
At least that was my understanding.
Yes. That I believe if you put it that way, then we will.
I can assure you that that is the way I understood it.
Okay.
Yeah, so let's proceed.
The most important thing, Your Honor, is how you understood it, and we are glad you understood it right. So what our submission here, Your Honor, there's one fundamental question that is being asked: that why do we need another day? That in our affidavit we have not given the reason why. We did not have an opportunity to state what is in our affidavit because the court already has that written affidavit. Yeah. The defense has that written affidavit. But for purposes of clarity and record, this is why we request for those extra days. We are saying that when we appeared before you, exhibit
Pastor Ezekiel ambaye sasa hivi anazungukwa na huu tata aliokokea kwa crusade yetu ya Tononoka mwaka wa 2000. Hapo ndio tumeanzana na yeye. Pastor Ezekiel amekuwa kwa kanisa la Maximum Miracle Center